Okay, good afternoon, everyone. Thank you for joining us for our newly elected officials training. As you know, we usually do this a lot of times on an annual basis, but every year following the elections, for sure, we've had a little change this year, obviously, with the pandemic. So instead of doing our in-person 2-day trainings that we normally do here in Springfield, we're doing the webinars and having those in breakout sessions on different subject matters over the course of March and probably into April. So today we will be doing the webinar from 1 to 3 p.m. We do have a schedule for 2 subject matters. One will be ethics and public integrity, and the other is parliamentary procedures for meetings. As attendees, you will be muted. However, you do have the chat box that you can type in questions throughout the seminar, and also ask questions of our presenters. We will also have a Q&A session at the end of each presentation today that you can also ask questions and get some direct responses from our presenters. We're very fortunate again this year to have our collaboration on this first webinar series with the law firm of Ansel Glink, and many of you have known Ansel Glink or probably utilized them. They have a long tradition of high quality representation of Illinois local governments. As you know, today joining us for one of the presentations will be Carrie Lynn Craffiter. Carrie Lynn has experience, as you know, primarily working with local governments. We have worked with her before. She has spent her entire career representing Illinois municipalities and local governments and public officials. She serves as the primary attorney for the Municipal Clerks of Illinois, and she's the former chair of the Chicago Bar Association's Local Government Law Committee. So we will begin with Carrie just shortly. We also have Steve Mayhart on with us today. Steve has represented local government entities for over 35 years in all aspects of municipal law, including governmental practice and procedures, zoning, labor, and employment law issues, and of course, representation of municipal boards and commissions. Prior to that, for more than 30 years, Steve served as corporation counsel for the town of Normal. So we are very fortunate to have them presenting to us today. So with that, I'm going to go ahead and turn it over to Carrie Lynn, and she'll get us started on ethics and public integrity. Carrie Lynn?
Thank you. Hi, everybody. Nice to have this virtual format to present to you. And thank you for taking your time out to learn about ethics, because we at Ansel Glink are trying to fight governmental corruption from within. I think as long as we are anti-corruption in Illinois, we're going to have a lot of work. But we represent over 200 public bodies. And what I've learned in the course of my representation of these public bodies is that it's not that people often get involved in local government to engage in corrupt, unethical practices, but people inadvertently slip into practices just because they didn't realize. And I'll give you an example that just happened this past week. I received phone calls related to township officials in 2 different counties, both of whom were doing business with the township, they had businesses that they own, and they were doing business with the township. So they were voting on contracts that they were basically awarding themselves. And in one instance, it was totally a pass-through thing where a township supervisor had a computer company and she had licensing software, and she was passing it through to the township for her costs. So it was actually saving the township money that it would otherwise have to pay. And she was just so surprised to find out that was a prohibited act. And she was shocked about that. And she immediately, it was called to her attention by a watchdog group. She immediately thanked them publicly and stopped the practice and everything. And we had another situation in another township where it was the same thing, where people just didn't realize the extent of the laws, because sometimes it seems like you're doing a good thing and it's unethical. So thank you for taking the time out of your day to listen to kind of our overview of these ethical considerations. A lot of them you will see as we start to talk about them. We could probably do an hour seminar in each of the topics. So I'm not going to do a comprehensive ethical seminar today, which would take hours and hours. Instead, I want to give you a general overview of the top ethics laws that you should be aware of. And if you need to do a deeper dive into any of these, then contact your state's attorneys. We have worked with various state's attorney's offices as special counsel for different matters that come before county boards. So we're kind of up on some of the things that come up. But what I wanted to cover today, let's see if I can go to my next screen. I'm either going to click down or why is it not doing anything here? I can't advance my screen. Oh, there we go. All right. These are the top laws that I'm going to cover today. The State Officers and Employees Ethics Act, that covers prohibited political activities, gift ban. It also recently was amended so that it also covers sexual harassment laws. There's the Public Officers Prohibited Activities Act. I'm going to talk about prohibited interests in contracts, procurement issues, and the Illinois Governmental Ethics Act. And then we're just going to touch on a couple of other things. But if you have any specific questions, please put them into the chat. And Kelly, because I'm sharing my screen, I have the seminar thing closed right now. So I can't tell if people are asking me questions directly. So if any come up, if you could just let me know about them, that would be great. Okay, so let's start with the State Officials and Employees Ethics Act. Now, this is actually legislation that was designed to cover state officials, but it was made applicable to counties, and it requires all counties to adopt an ethics ordinance or resolution. So the first thing you need to do is make sure that your county has adopted this. And if your county has, read your ordinance, because your county may have adopted stricter ethical requirements than what I'm going to talk about right now. So find out if you have an ethics ordinance. If you don't, you need one. Find out what it says. But generally what it's required to do is, first of all, regulate the solicitation and acceptance of gifts by your public officials and by your county employees. It also has to regulate political activities of officers and employees. And as of about 2 years ago, it was amended to require the adoption of a sexual harassment policy. So you need those elements. You need a gift ban act, you need regulation of political activities, and you need sexual harassment all addressed in your ordinance. And it may be that your county adopted one of these ordinances a while ago, and you just need to update it to pick up the sexual harassment training if you haven't done that. But the one thing I want you to know about this is not only does the law that we're about to talk about apply to elected county board members and appointed county board members, which you would expect, but it also applies to any other governmental entities to which the county board makes appointments. So I put this language in there. This is the statute. For those of you who are attorneys, you'll understand what that little code at the top means. But for those who aren't, where it says ILCS, what that means is the Illinois Compiled Statutes. So this is in volume 5 of the Illinois Compiled Statutes, chapter 430, and then the section is 70-20. So I have included the statutory references because I would like to submit this to the Attorney Registration and Disciplinary Commission so that any attorneys listening to this can get continuing legal education credit for it. And for those of you who are not attorneys, sometimes you just like to look up the laws and see them yourself. So you'll have the reference to do that if you can. But anyway, just be aware that what I'm talking about doesn't just apply to county boards, it's also your umbrella organizations. So let's start with the Gift Ban Act. When the Gift Ban Act was originally adopted, it was overly broad and it was challenged as being unconstitutional, and it subsequently was held to be unconstitutional, and then it was kind of readopted in a different form. So let's talk about what this means. We're going to talk about what exactly is banned, who has to comply with this, who's subject to it, what is considered a gift, and who's restricted from giving gifts. So as I mentioned, the Gift Ban Act was repealed and it's now covered within the section of the State Officials and Employees Ethics Act, which is made applicable to counties. So just to paint a broad brush, the gift ban provisions bar the solicitation of any gifts from a prohibited source. Now that sounds really simple, but it gets convoluted in a couple of different ways. So first of all, what's a prohibited source? I guess the simplest way to think about it is that a prohibited source is anyone who's seeking to do business with the county or anyone who's doing business with the county. Because what we don't want to happen is we don't want somebody giving a gift in exchange for a favorable contract. So we're trying to avoid bribes, really, is the bottom line when it comes to the statute. So people are prohibited sources if they're seeking official action from you, if they're coming before the county board on a petition, if they're seeking anything from you, if they're seeking a contact from you. And you'll see on the screen, I've included ellipses. And what I have taken out is language that says they're seeking official action from a person, from you, if you're an elected or appointed official who can vote on something, but it also covers employees. So it's seeking official action from the entity if they're giving a gift to an employee. So where you see ellipses, that's what that stands for. The other thing is, if you conduct regulatory activities over the prohibited source, that also falls under this, and they can't give gifts to people. With the exceptions we're going to talk about, there are exceptions. A prohibited source is also somebody who has interests that might be affected by some of your official duties, someone who's a lobbyist, or someone who is an agent, spouse, immediate family member who's living with a prohibited source. So it's painted fairly broadly to try to catch any possible corruption. So if the wife of your printer comes in and they want to give a gift to your employee, and in exchange they're expecting a renewal of that contract, that's the kind of thing that could be a problem. I somehow got muted, sorry about that. We talked about who the prohibited sources are, but also we have to talk about who does this apply to. So we're talking about gifts to any elected officials, any employees, their spouses, or any of their immediate family members. Okay, what kind of gifts are permitted? Well, there's a ton of exceptions to the ban. So as I said, a gift is anything of value. An exception would be any opportunity, benefit, service, anything that's available to the general public. So for example, there's a parade going on and there's a local print shop in the parade and they do business with the county and they're giving coupons to everybody on the route. Well, if they give coupons to the county board members and those are negotiated, that's not a prohibited gift because that's something that's available to the public at large. The other exceptions are if there's anything bought at market value. So if you have a county board member who buys a printer from the printer who's doing business with the county, that's fine too, even if there's a sale. So if they've paid market value for it, then it's not a gift. Other exceptions that we sometimes get questions about are political and fundraising contributions. So if you have a county coroner who is running for re-election and a vendor makes a political contribution, that's acceptable. And the reason that's acceptable is that there are other campaign finance laws that require the disclosure of that. So that can be made a matter of public scrutiny and the public will be aware of that. And if they want to allege that that's a bribe, they have, they can do that in a political platform. So fundraising and political contributions do not constitute gifts. Other common exceptions are educational missions or travel expenses for a meeting to discuss county business, gifts from relatives, inheritance or other transfers at death, and also interoffice and intra-office gifts. Another exception that comes into place sometimes frequently is gifts that are provided on the basis of personal friendship. So the county board member has a relationship with the county's IT contractor because they were college roommates and the contractor gives the county board member a wedding present. They would have done that anyway, even if they weren't doing business with the county because they were personal friends, notwithstanding the contractual relationship to provide services to the county. So that's also acceptable. Okay, now this is like my client's favorite exception. There are two exceptions related to food. So food and refreshments. So if let's say that you go to the county conference and someone that you do business with is there and they want to buy you a drink, well, they can do that. They can also take you out to dinner, provided that the amount that you spend, it does not exceed $75 per person on a single calendar day, and the food is consumed on the premises and also purchased and ready to eat. So if you're at a conference and a vendor has sponsored the coffee hour, it's okay to drink the coffee. So that's part of it. So what we at Ansel Blink do when we take our clients out, we take them out at 11 p.m. So we have that 1 hour from 11 to 12 where we can spend $75, and then from 12 to 1 we can spend another $75, because that then strictly complies with the single calendar day. Anyway, I'm joking around, of course, because we have to try to spice up ethics somehow, right? Okay, so the other one, and food somehow gets linked into this exception too. You can accept items from a prohibited source during a calendar year as long as it's worth less than $100. So if your favorite, I don't know, one of your supply vendors for pens comes up and they give you popcorn at Christmas time, you can accept the popcorn. Or if somebody gives you a very nominal Christmas gift, if it's less than $100, you're fine. And that could, so this is in addition to the other exceptions like the food exception. So you can have both the $75 per single calendar day on site, that exception, plus the $100. So those are the key provisions that most of our clients have come up a lot. Now, what do you do if somebody actually gives you a gift in excess of the limits? Well, this actually happens more often than people think. We represented a park district that had a golf course, and the golf course vendor came to one of the trustees. Hold on just a minute. Sorry, I had like a very noisy airplane flying over me. And the golf course management company came to the trustee who was in charge of the golf course and said, hey, we have tickets to the Masters. We're going to buy a plane ticket for you to go there. We're going to get you into the Masters. We have a hotel room for you. It'll be great. And the trustee had not brushed up on the provisions of the Gift Ban Act. And so he accepted this and he went to the Masters. And when he came back, we were in the unfortunate position of telling him, guess what? That was a very nice gift, and you can't return it because you've consumed it and you've used it. So we need to now find out what the fair market value of everything that you just did was, because you have to make a donation to a charity in that amount. And so we had to value the plane tickets, the hotel, he had to pay for the tickets. And the Boy Scouts in that town really were the beneficiary of that because they got a very large donation. And I mean, sometimes things come up where, hey, someone has Super Bowl tickets and you really want those Super Bowl tickets. As long as you are making a contribution to a charity and what the fair market value of, if it's something like hard to procure that you really want, you can do that. But of course, be careful with it. And if you see yourself spiraling into a situation like this, make sure you talk to your local state's attorney about it, just so you're square ahead of time, because you don't want to be headlines in some watchdog group's blog. Okay, so the next thing I want to talk about, so the first part of the Prohibited Officers Activities Act was the Gift Ban Act. The second part is prohibited political activities. And this usually comes up, I believe, more often with state officials than local government officials like county officials, but sometimes it does. So you need to be aware of this also. So we have to make sure that when you're running for office and you're wearing your hat as a candidate, you're not using public funds for political purposes. So you can't use the copy machine at the county. You can't use county workers on paid office time. So let's kind of unravel what we're talking about here. So no officers or employees of the county may perform prohibited political activities during compensated time. So that means we can't require county employees to perform political activities as a condition of county employment. But if they want to volunteer for you while they're off work, they absolutely can do that. They still have protected First Amendment rights to do that.
Carrie Lynn, this is Kelly. We did have one question come in on the gifts. Can county board members buy gift cards for county employees?
Yes, because one of the exceptions is inter and intra-office gifts. So you
Okay.
absolutely can do that. And the reason is, think about it. When we talked about the policies behind the Gift Ban Act, we don't want people to be able to bribe you, right? So if it's county officials recognizing good work that county employees have done during the year, that's absolutely fine. So you can, that's fine to do that.
Thank you.
Okay, so back to the fact that employees can't perform work on compensated time. What does that mean? Okay, now surprisingly, even though your county employees are likely paid for vacational and personal time or comp time off, compensated time does not include that. So if they're on vacation and they're going to engage in polling for you, they can do that. If they want to take a PTO day to man a precinct on election day for you, they can do that. And if they have comp time, they can use that. Even though that's paid for, that's not considered compensated work time. Now, it's a little stickier as applied to public officials. So you yourself, you're a county employee and you receive a salary for that, right? Or you receive compensation for serving in your county capacity. And how do you know when you're performing county activities versus going to a function where you're kind of there in your county capacity, but you also want to talk to people about the fact that you're running for office? That's okay. I mean, it's public officials, you're not like paid on an hourly basis. If you are paid on an hourly basis, you shouldn't be campaigning at that time you're being paid on that hourly basis. But if you're salaried, you don't really have an on and off duty time period. So it's okay for you to engage in political activities. And this act prohibits 15 different things, but they're all the things that you think they would be. Fundraising, circulating petitions, polling, going door to door, canvassing, participating in a recount. So if this becomes an issue in your jurisdiction, just go through the 15 specific different things that are involved, but I didn't list them all here. By the way, so I wanted to tell you, our office writes some publications. We write the Illinois Municipal Handbook, which we do free of charge for the Municipal League. And it kind of goes through all of the laws on municipalities, but it also goes through some of these broader laws, and that's available for purchase through the Illinois Municipal League. We're updating that book this year. We also have we work with the township officials and we write a book for them. It's the Township Officials of Illinois Laws and Duties Handbook. And for those of you who are on this call who are state's attorneys, I would recommend you purchase both of those books. The township book can be purchased from Township Officials of Illinois. We don't make any money from it, but your civil divisions, we've been told by the civil divisions of different states attorneys' offices that they think they're a really good reference when they have to evaluate and provide legal advice to municipalities and townships. But some of you might want it because it does have all of the itemization of all these other laws in it. That's why I mentioned those. We're updating both of those books this year. Okay, now the Public Officers Prohibited Activities Act is the next law we're going to talk about, and that talks about several things that come into play for county ethics. One of them is a prohibition against holding dual offices, which is very confusing, and that goes in the conflict of interest law, so we're going to talk about that. And the other is prohibited interests in contracts. So let's start out with prohibited dual offices. Now, this is another one of those laws where there's a rule and then there's a bazillion exceptions, okay? So the general law is that no member of a county board can hold another elected or appointed office other than, and then you'll see there's all these offices here: chairman of the county board, member of the regional planning commission, alderman or trustee in the town if there's less than 1,000 inhabitants in the town, in a county with less than 50,000 inhabitants, forest preserve district trustee, county extension board, emergency telephone system board member, board of review, and you can also serve as a public administrator or a public guardian for other public bodies. Now, you can't hold this during your term of office. If you're retired or when you're not holding a county board office, you can then hold other offices. The Illinois Attorney General's office has a whole index of compatible and incompatible offices, and they go through an analysis to see whether or not you can simultaneously hold two offices. And predominantly, that analysis looks at whether or not, in your capacity as a county elected official, you are engaged in a contractual relationship with another unit of local government where you're also an elected official. There are some instances, and we'll talk about a few in a moment, where they're permitted by law, just like I said up here. The ones located on the screen are permitted by law. Otherwise, you have to resign first. Now, this law does not prohibit an elected county official from holding an elective office in another unit of local government, as long as there's not a contractual relationship between the county and the other unit of local government. But you really have to be careful, because counties have a lot of intergovernmental agreements, and sometimes they have very long-standing intergovernmental agreements. So just because you didn't enter into an intergovernmental agreement within the past couple of years doesn't mean that there's not one that you could be called to vote on, or that you may be subject to. So you could inadvertently have a conflict of office. So for those of you who do hold offices in other public bodies, make sure you have an opinion from your state's attorney saying that that's okay. Because the state's attorney can look through the attorney general opinions and look at all the different statutes and also determine whether or not you have these intergovernmental agreements that would create the relationship that's problematic.
Okay, Carrie Lynn, we have one question kind of pertaining to that, if you don't mind. It just says, can county board members also, are they prohibited from holding an elected trustee position in a township?
I would, yes, you know what? I will answer that in a moment.
Okay, thank you.
Yeah, there's a special law that relates to townships, which is a little bit convoluted. And that's what I'm going to talk about right after this. So let me just stay in order with my presentation. So there's some weird exceptions by populations. And one of those is that if you're a county board member with less than 550,000 inhabitants in your county, you can be the township highway commissioner. And you can serve in all sorts of school positions if you're in a county with less than 40,000. So you can simultaneously hold those offices. And here's the penalty provision. It's a class 4 felony if you're actually convicted of holding dual offices, and you also then vacate all of your offices. So be very careful about this. So to the township question, townships are near and dear to my heart. I am a recovering township trustee out of York Township, which is in DuPage County. And I don't know what was happening exactly in 1974, but in 1974, there was this law passed called the Public Officer Simultaneous Tenure Act, and it only addresses the interrelationship between county officers and township officers, no other officers. And, you know, depending on how you read the act, it appears that county board members can also be township supervisors at the same time. In other parts of the statute, though, it looks like they can only do that if it's a county with less than 100,000 in population. So if that's your particular issue, seek advice from your state's attorney on this. I have serious concerns about the interplay between this law and the conflict statutes about engaging in contracts. I think notwithstanding this law, it's a problem. Oops, sorry, my Siri kicked on for some reason. I think it could be a problem if you are a township supervisor and you enter into an intergovernmental agreement with a county and you vote on that contract with the county and you vote on that agreement with the township board. And it's even more problematic because townships, in order to pass any laws, they are special entities and they have that rule that you need 3 affirmative votes. So if the supervisor is the 3rd vote and it passes like 3-2, I don't know, I just think there's problems with that. So be very, very careful and make sure that you discuss this with your state's attorney. But this also addresses the issue about township trustees. So you'll see here that it's okay to be a county board member and a township trustee in a county with less than 100,000 in population. I guess the best practice would be abstain if you do have intergovernmental agreements from the votes, both of the township and of the county board. I still think that's a little bit problematic though, because the laws with respect to how votes are counted say that if you abstain on a measure, it still counts with the majority. And in addition, there are a number of cases that find, as a matter of common law, that an abstention from a vote does not eliminate a conflict of interest. So again, that's why I just want you to take special care if this issue comes up with you. And then the final thing is that you can be a county board member and an assessor or a township clerk in counties with less than 300,000 in population. And I think part of the reason for some of these rules, since we represent downstate townships, you know, it's a whole different world, as you all know, south of I-80, right? And we often have public bodies that call us and say, we don't have enough people who want to run for office here. So sometimes when you have the go-getters who actually are committed to public service, they want to hold more than just one office. So I suspect that's why we have that. So anyway, that's like a general overview of holding these dual offices. The next part is prohibited interest in contracts. And this holds that, it says trustee, it should be commissioner or county employees. They can't be directly or indirectly interested in any kind of financial contract or work or business, the sale of anything paid for by the county, or the purchase of real estate or property sold by the county. So that's a little tricky. And the part that's tricky is the part that talks about indirect interest, because usually county officials know that they can't directly benefit financially, but sometimes it's like, oh, we didn't realize that because we have a majority of shares in this corporation, or our spouses had it, or whatever, that they might have an indirect interest. So just another, like I said, we can't go into every single little thing, but I want to alert you to these red flags that when they come up, you can talk to your state's attorney about specifically your situation. Okay, so this also applies to businesses that you might own or have a direct or indirect financial interest in. So if you own a company and the company wants to do business, be careful. Even if, like the very example I started out this webinar with, talking about the township supervisor who didn't realize, since she was only charging costs through her company of this discounted computer software, that's a problem, sadly. And maybe, you know, we work with some watchdog groups because they share our goal to try to increase accountability and transparency in government and fighting corruption. And one of the things we've been talking to them about is, you know, there are some of these ethics statutes that are a little bit ridiculous. And if watchdog groups agree to that, like, you know, like you can get a discounted service to someone, like maybe we have to do a legislative fix on some of these things, and we'll have to see what comes of that. Our law partner, Chris Welch, is the newly elected Speaker of the House, replacing Mike Madigan, and it's a new day in Springfield, and I think we're going to see a lot more bipartisan cooperation going on, and I think we're also going to see things like some reforms that have been proposed. I think they're going to be unblocked. For example, the Chicago Bar Association has been attempting to amend the election code for like 40 years, and that was always blocked by Madigan. But I think some of that stuff's going to be freed up. So while we're not really advocating that there needs to be like a lessening of ethics, there are some ethics laws that we probably, they're like overly broad, and those are the things we might be able to have fixed a little bit. But in addition, if you're a county board official or county official or an employee, you can't represent anyone before the board. You cannot accept bribes, obviously. And there are some exceptions. I feel like everything I'm telling you, this is the rule, and then there's a bazillion exceptions, right? There's some exceptions, though, when interest in contracts are permitted. And I think the easiest way to think of this is, let's say that you are participating in a retirement fund, and you give your money to Fidelity, and they're investing in ComEd, and ComEd wants to do a contract with your county. Well, that's okay, because if you have less than a 7.5% ownership share in the company and you disclose that, and if you follow these rules here, then there are times when contracts are permitted. You need to abstain from voting on the award. The majority of the board, without you voting, would have to approve it. If there's a bid, if the amount of the contract goes over $1,500, and if the aggregate sum awarded to the company doesn't exceed $2,500 per year. Sometimes with downstate communities, there's another exception where, and again, for some reason this always comes up with townships, there is like a vendor in town, like it's the only car repair shop in 80 miles, and he wants to sell parts to the township. And you can do that if, again, you disclose the interest, the majority approves the contract with the member abstaining. The contract amount does not exceed $1,000, and the total contract amount for the whole year is $2,000 or less. So there are very narrow, limited exceptions to these contracting things. I would encourage you not to do it. It's just better not to. It's easier not to. But if you feel like you have to, and there's some benefit to the county, and you think you fall in it within an exception, again, talk to your state's attorney. Meanwhile, all the state's attorneys are like, we want this to stop because she's telling everyone to come back to us. Sorry about that. Okay. And then here's another third exception, which is if you have less than a 1% ownership share in a company. Again, it's so nominal that people don't think you're going to engage in corrupt practices, so there's an exception for that. Again, though, very serious violation if you do it, because it's a class 4 felony and could result in the forfeiture of the office. Oh, so one more thing. So basically, with everything that we've talked about so far, I've been going through the state laws, but your county, just like I mentioned in the beginning about the ethics legislation, you might have legislation that also covers all these things, either ethics legislation or other ordinances that your county may have passed about contracting or special disclosures, purchases. Make sure that you know what your county's ordinances say, because they could be more restrictive than what I'm actually talking about. Okay, the other thing I wanted to tell you about is another thing like related to procurement. And that is, if you have a situation where your county is entering into a contract in excess of $30,000 and you have a relationship with somebody who is who's an owner of that company or corporation or agency or whatever, and it's a family relationship, you have to disclose it. Now, it doesn't say that you can't award the contract. It just says you have an obligation to disclose it. Now, if a contract was awarded that fits in this category and it was not disclosed, the county can terminate the eligibility of that company as a vendor. So just be aware of that requirement. Also know that familial relationship is defined very broadly. Nieces, nephews, cousins, domestic partners, everything. So if you have that situation, again, look into that statute. And this is the part of that law that says the county can still approve that contract under those situations, as long as the county board member has disclosed the relationship. And I, again, would tell that county board member to abstain from that. So just be aware that that law is out there. Okay, now the other law that you should just be aware of is official misconduct. And the trick that, I believe that people go into public service because they want to be public servants, not because they want to do bad, although I have seen, sadly, limited instances of that. But this, again, is a trick where you can get caught up. And so here, if you intentionally or recklessly fail to perform a mandatory duty, well, that means you need to know what your mandatory duties are. And it's a good thing that the association is offering classes to newly elected officials so you can kind of become aware of what your duties and responsibilities are, so you're not engaging in some violation of them. Also, if you knowingly perform an act in excess of your authority. So let's say that you as a county board member decide to sell county property without a board vote or something like that, that's a problem. And if you accept any fees or solicit them that are not authorized by law. So we don't want any of you to get criminally prosecuted. So just be aware that that statute is out there. Okay, and we're kind of winding down what I wanted to cover today. There is another law known as the Governmental and Governmental Employees Ethics Act. And this law, I'm pretty sure you're familiar with, because if you ran for county office, you had to file your statement of economic interest with the county. And as you know from filling out that form, it's basically incomprehensible because they're really trying to figure out is, are you doing business with the county? Or is there some kind of contract between you and the county? But the way they go about wording that form, I always get questions about that because it's a little bit of a disaster. I go through and rewrite it so it says the entity for which you're doing business, just write county so you understand what it means. But you need to file this statement annually by May 1st. So if you have not done that, you need to do it. You need to do it every year. It's required of every officer and employee and candidates. Now, I'm the head of our election law practice, and my safest recommendation is even if you filed the form because you're in office and you are not technically required to file it again during the same calendar year that you're a candidate, just do it. Because I cannot tell you how many people I've defended in election petition challenges just because people think there's a violation even when there's not. So don't subject yourself to the hassle. Just fill out the form again, file it again, and save yourself from that headache. And this form discloses any financial interest that you have. So people can make sure that you're not doing business with a governmental entity or you're not seeking to. Okay, then the final thing I just wanted to touch on, and these are not actual laws, but they're considerations that usually come up with newly elected officials. In your capacity as an elected or appointed official, you may find that you have access to confidential information. Usually this comes up related to employees. So you might know about employee health conditions, other special circumstances, things like that. And just make sure that you keep that information confidential. There should be a special protection for those. There are certain laws that apply to that, but just beware that if you do go into closed session and you're talking about a personnel matter, you learn of something, that you want to make sure that you're not disseminating that information to people who aren't entitled to it. Also, probably the #1 question that I get when I teach classes on practices and procedures to boards is how can we prevent people from disclosing information from closed sessions? And really, there's no law that prohibits people from doing that. You're actually never required to go into a closed session. That's something that you can just do in certain instances for reasons which are legitimate. For instance, if you're coming up with a proposal for a union and strategy like that, you wouldn't want to discuss that publicly, and the same thing with litigation strategy. But sadly, there's no law that prohibits people from discussing things that were discussed in closed session with people outside closed session. So this is just a matter of your own personal integrity, and I would just encourage all of you to take the high road. And sadly, what I know from teaching classes like this for 30 years is that the people taking this class right now who actually are taking their personal time to learn about ethics are not the people that need the class. It's the ones that aren't taking this. Like, you're probably listening to this saying, hey, I know several people I need to have take this class, right? It always kind of works out that way. And the same thing with personnel files. But other than that, that kind of covers the broad material I wanted to get through today. If you have questions, I'm happy to have them in the chat.
Okay, thank you, Carrie Lynn. Is there any additional questions for Carrie Lynn today regarding the ethics?
If not, people can always email us. You know,
okay.
My email information on screen. Same with Steve Mart and Eugene Bolotnikov, who are going to address you next. You know where to reach us. And also, for those of you who are just interested in having and like often like frequent updates on the law, if you go to our website at www.ansoglink.com, at the top, we have 2 blogs you can subscribe to. One is called the Municipal Minute, and that doesn't just talk about municipalities. It talks about general local governmental issues. And my partner, Julie Paffendorf, usually posts to that 3 times a week, and you can get updates for that. We also have the Workplace Report, which talks about local government employment issues. So feel free to subscribe to those. Those are free of charge.
Great, thank you, Carrie Lynn. I will definitely share your contact information with the attendees today. And we'll also, we will be linking you in to this recording. If you need to share it with some of your other elected officials or colleagues, we'll do that today as well at the end of the next presentation. And that will be provided through a link and blog through ANSOGlink. So thank you so much, Carrie Lynn. I know we were very rushed today compared to when we're in person, but you did a very comprehensive job. So thank you so much.